Okay, so good evening po taong bayan at ngayon po pag-usapan natin yung mga contempt, indirect contempt cases po filed against Congressman Sendanya of Akbayan Party List, Professor Heydarian, and Secretary Larry Gadon by Attorney Topacio and Company. Okay, so before po tayo mag-start, just a quick Maritesan portion lang po. So I would just like to thank everyone po na bumati sa akin nung birthday ko last July 29. Okay, so medyo matagal na nga pala na na gumawa ako ng video. July 27 pa po yung last. So anyway, na-miss ko po kayong lahat and after 4 days po, I am back and today we will be talking about contempt. And again, thank you po sa lahat ng bumate and ngayon po, start na tayo sa discussions natin. So kung magustuhan niyo po itong video na to, huwag niyo po sana kalimutan i-like mismo itong video na to and of course po mag-subscribe sa YouTube channel ko para po updated kayo kung may bago tayong upload. Okay? So anyway po ngayon, let's us now go to the discussion. So yung contempt po that is governed by our rules of court, specifically under Rule 71 po yan. And yung contempt po, there is two ways to commit this. So unang-una po, direct contempt. So when you say direct contempt, yan po yung pag may gawin kayo mismo na something disrespectful in the presence po mismo ng mga judges or justices natin. Okay? So direct contempt, pag nasa presensya po kayo or nandun kayo mismo sa harap ng mga judges or justices na gumagawa ng kalokohan. Okay? Yan po yung summary niyan. And for indirect contempt naman, there are specific ways to commit this. So kung makita po nyo dyan, Rule 71 Section 3, meron pong A, B, C, D, E, F, G na ways to commit it. Okay? So indirect contempt naman, the way to do this is hindi po kailangan na nasa presensya kayo ng mga judges, ng mga justices natin or mga courts natin. However, meron po kayong mga ginagawang actions na disrespectful to the courts po natin. Okay? So yan po yung difference ng direct and indirect contempt. So regarding po sa mga legal luminaries natin that will fall under more or less po pwede yan pumasok dito sa letter A. Misbehavior of an officer of court in the performance of his duties or in his official transactions. Okay? Kasi tatandaan po natin when you are called a legal luminary, then more or less po or most likely you are a member of the judiciary as a lawyer. Okay? Because if you are a lawyer po kasi automatic po yan na officer kami of the court. Nasa lawyer's oath po talaga namin yan na manunumpa kami as officers of the court and that we swear to uphold and protect the Constitution and the laws of the land po and to not influence or induce other individuals or our clients to violate the Constitution or the laws. Yan po yung sinumpaan namin as a lawyer. Okay? So again, as a lawyer po, we are automatically officers of the court. Therefore, pwede po yun siya pumasok dito under letter A, yung mga ganong statements po ng legal luminary, provided however na they were doing that in the performance of their official duties or official transactions as an officer of the court. Okay? So kung yung mga statements po ng mga legal luminary na yon na ini-induce or in-influence nila yung mga ibang tao na i-violate yung Supreme Court decision, if they did that in their capacity as a lawyer, di pwede po yan sila pumasok dito sa letter A. Okay? Kaya nga in my previous video, sinabi ko that can be considered as a criminal act on the part of dun sa sa public officer. Kasi yung public officer dun yung mangyayari siya yung hindi susunod sa isang batas eh. So if you perform an official function po nyo as a public officer tapos that is against a Supreme Court decision, a law of the land, pwede po yan pumasok under. So when you say it is the improper use of your office or your functions in performing your official duties. So yun po yung criminal act na pwede pumasok doon. Tapos dagdag pa po doon yung mga legal luminary. Aside from them, pwede maging principal by inducement doon sa case, pwede rin po sila pumasok pa dito under letter A section 3 of Rule 71 for indirect contempt. So yun po yung mga potential and possible liabilities po ng isang legal luminary na nagsasabi po ng mga statements that will induce, influence, or coerce other individuals to violate po a Supreme Court decision. Okay? Pwede yan sila pumasok dito under letter D. Any improper conduct tending directly or indirectly to impede, obstruct, or degrade the administration of justice. Okay? So, una-una po, ang take note natin dito, ang sinabi nga actually is tending only. Diba? So, when you say tending, that is a possibility na meron kang gagawin that will impede, obstruct, or degrade the administration of justice. Therefore, dapat po yung gawin mo is not an actual obstruction or degrading, but rather, pag pag it will only tend to, yun nga, to impede, obstruct, or degrade, pwede na po yan siya maging indirect contempt. Okay? So again, take note po, any improper conduct tending, di ba? Hindi actual po yung requirement ng batas natin. As long as there is a possibility that can be considered as indirect contempt under letter D, pag yung actions mo po has a chance to impede, obstruct, or degrade the administration of justice. Okay? Pero hindi po ibig sabihin na ginamit dito na word is tending is dapat yung kaso is flimsy or mahina tapos pwede na siya ma-cite for indirect contempt. Hindi po yan ganun naman. Meron din pong protection na ginawa yung Supreme Court dyan from abuses po sa mga Supreme Court decisions nila. So yung definition po ng tending dito ng Supreme Court sa mga kaso nila ay dapat yung tending na yan has a serious or imminent threat of actually happening. Hindi yung suntok sa buwan, di ba? Hindi po yung kung may gagawin ka or may statement ka tapos sobrang suntok sa buwan na may impede, ma-obstruct or ma-degrade mo yung administration of justice. Okay? So yung requirement dyan, again, dapat yung tending na yan has a high chance po na magkaroon pa rin ng impede, obstruct, or degrade of the administration of justice. Okay? So in other words po, stricto yung Supreme Court dyan. And as a matter of fact po, sa Supreme Court decision, ang kailangan ng evidence dyan is proof beyond reasonable doubt. Okay? So again, ulitin ko lang po, tending to directly or indirectly impede, obstruct, or degrade, provided however that it must be serious and imminent. Okay? Na mataas po yung posibilidad na mangyari nga yung impede, obstruct, or degrade dun po sa mga actions mo para po pwede ka maging liable for indirect contempt under letter D of Section 3, Rule 71 of the Rules of Court. Okay? Yan po yung gusto ko lang din klaruhin talaga. So una-una po tingnan muna natin yung statement nito ni Congressman Sendanya. So yung summary po dito, yung sabi ng Batas PH, Akbayan Solon warns Supreme Court Justices of possible impeachment traps. Okay, so kung ito lang yung statement niya, ito lang, natatakutin niya. Actually, hindi nga to threat eh. Pagbasahin natin tong ito pong header ng post na to. Pagbasahin po natin to, kung ako po tatanungin yung assessment ko po, this is not something that has a chance to directly or indirectly impede, degrade, or obstruct the administration of justice. Kasi kung tatandaan po natin, totoo naman talaga na yung power of impeachment is with Congress. Okay? Therefore, sinasabi lang niya dito, kung ito lang po, again, kung ito po yung babasahin natin yung header, hindi pa po ito yung full assessment ko kasi nasa header pa lang po tayo. Okay? So again, pag sa header pa lang, this is a safe statement po na hindi siya pwede or mahirap po siya makonsider as indirect contempt based po on my professional assessment. Okay? So ngayon, punta po tayo sa iba pa niyang statements. So ito po sabi niya, impeachment case versus Supreme Court Justices, and then basahin na lang po natin directly yung mga sinabi niya. Ito pong may quotation marks. Our justices chose to serve the interests of the Dutertes and shield the VP from accountability. Filipinos deserve an independent Supreme Court and should hold the court accountable if it falls short of that. May kalalagyan ang pagtataksil sa taong bayan. Kasali na riyan ang posibleng impeachment. Okay? And then next, again, yung quotation na po na sinabi niya mismo, nireduce ng Supreme Court ang kanyang sarili bilang Supreme Cuddler of the Philippines. The dismissal of the impeachment sets a dangerous precedent. Lahat ng tiwaling politiko pwedeng magtago sa likod ng Supreme Court at takasan ang pananagutan sa sambayanan. So kung makita po ngayon ninyo yung full context ng statement niya, medyo iba na po, 'di ba? Yung substance ng statement niya from this header. Pag ito general statements, okay lang. Pero pag basahin niyo na po yung actual, medyo may na po, 'di ba? May mga patama na and mga conclusory remarks. So if we will look at this statement niya, ako po personally, ang tingin ko, pwede to siya ma-consider as a contemptuous statement. Kasi unang-una po he is giving conclusions na yung Supreme Court daw natin are only serving the interests of the Dutertes. So that is an allegation. Where is your evidence to establish that? Diba? Hindi naman purkit nag-decide yung Supreme Court in favor of a certain person who happens to have the last name of Duterte is ibig sabihin, pinaboran lang niya yung Duterte family. Diba? It does not work that way. As a matter of fact, sa Supreme Court decision, may legal basis nga pong mga sinite dun eh. So dito pa lang po, posible to siya makonsider as, again, as indirect contempt, considering na para pong there is a chance ngayon na yung mga tao will start to question the impartiality, the integrity of the judicial system natin. And not only of any court but our higher court po dito, the Supreme Court po yung kine-question niya mismo. So pag doon baka ma-insight niya ngayon yung mga taong bayan tulad po natin na we start questioning the decisions of the Supreme Court. So pag ganyan po, ano mangyayari? Pag ganyan po, there is now a high probability or high chance na magkaroon ng judicial instability considering pa po na he is a public figure na meron din talagang mga taong nakikinig sa kanya. Tapos kung yung mga tao po ay maniwala talaga sa kanya tas hindi na sumunod sa mga Supreme Court decisions, sa mga Supreme Court orders, and then of course that will clearly impede po the administration of justice in our country. So yun po yung sa tingin ko lang pag ito na po basahin talaga natin yung full statement niya. Plus titingnan po niyo, sinabi pa niya ni-reduce ng Supreme Court ang kanyang sarili bilang Supreme Cuddler of the Philippines. Diba, if you make remarks like this kasi, it might seem political speech lang, but we have to remember, political speech, the freedom of speech po is not absolute, diba? Yes, it is a fundamental right po natin yan that is in the Bill of Rights. However, it is not absolute in the sense na if there is a dangerous tendency po of a substantive evil na posibleng mangyari sa bansa natin, pwede po yan i-regulate or i-penalize ng ating batas or ng ating courts, di ba? So dito sa situation ni Rep. Sandanya, since he is making statements that can possibly which leads to yung disobedience ng taong bayan po sa judiciary natin, so hindi na po yan siya protected ng free speech or posible po siyang ma-argue na hindi na siya protected ng free speech. Yan po yung professional assessment ko of the situation. Okay? Kasi iba na po kasi yung mga ganitong statements na may mga conclusion ka na you are clearly insulting, and yung mga statements po ganito will clearly affect po the reputation po and the impartiality of our courts from making mga objective discussion na statements. Diba? Kasi ito, yun nga, sinabi niya Supreme Cuddler, conclusion na agad siya. Tapos Supreme Cuddler kasi daw they only serve the interest of the Dutertes, yung Supreme Court. At dahil daw dun ngayon, pwede lang tumakbo sa Supreme Court para magtago daw yung mga abusadong public figures or public officers po. So yung question na kasi dyan, what is your basis to make those allegations? That is very malicious if you ask me. Pero kung naggumawa sana to siya ng statements, let's say na sabihin niya in the old impeachment cases po, yung Francisco versus HOR, the requirement of initiation was only this and that. However, in this case ngayon, yung Duterte versus HOR, yung ginawa na ng Supreme Court, the requirements for the initiation is already this and that. In short, parang i-compare mo ba para makita talaga yung full picture. Pag ganun, medyo objective po yun. So pag ganun, hindi yun siya contemptuous statement. Pero like what I said, mga ganito nga mga personal attacks, pwede na po siya i-argue talaga na this can be considered as indirect contempt. Again, that is my professional assessment kasi this is very malicious po Kasi kung titingnan po nyo yung mga ganitong statement, if you apply it to regular libel laws natin, this can be considered also as libelous statement for private individuals, diba? Kasi masisira na yung reputation ng private individual sa mga ganitong statements So how much more kung i-direct mo sa Supreme Court, diba? Pwede rin masira yung reputation ng Supreme Court, which will yun nga po in effect result to the image of the Supreme Court of impartiality maapektuhan sa public, then which could potentially result to an obstruction po of the administration of justice dito po sa bansa natin. Okay? And then yung kay Secretary Gadon po, more or less same lang din po yung masasabi ko doon kasi yung sinasabi doon ni Secretary Gadon, based po from the interview na napanood ko sa kanya, tinatawag niya na tuta daw yung Supreme Court ng mga Duterte paulit-ulit. So more or less the same po yung substance or yung message naman na cuddler nga yung Supreme Court daw ng Duterte family. So more or less ganun din po yung statement ni Secretary Gadon that can also directly or indirectly lead to impede, obstruct, or degrade the administration of justice po sa bansa natin. Yung kay Professor Haydarian, yun hindi ko makita or mahanap sa sa page niya yung actual statements niya. So in short, wala po akong ma-explain as to him. But for Congressman Sendanya and Secretary Gadon, more or less same naman na yung conclusion nga nila, Supreme Cuddler of the Philippines as per Sendanya, as kay Secretary Gadon, tuta daw yung Supreme Court. Okay, at tandaan po ninyo, di ba? Kaya ako po binigay na example kanina, yung dangerous tendency test because this is crucial kasi free speech po yung pinapag-usapan dito, specifically yung right nila to conduct political speeches. So pag free speech po kasi, that requires what we call the strict scrutiny test, and under the strict scrutiny test, one of the requirements po dyan is the dangerous tendency test. So kung mataas po yung chance na magkaroon ng bagay na dangerous na substantive evil that the state has a right to protect against, pwede na po i-regulate ng korte or ng government natin yung right to free speech. Okay? Because free speech, yes, it is a fundamental right under our Bill of Rights. However, it is not absolute. When it it will clearly lead to a dangerous tendency of a substantive evil that the state has a right to protect against. Okay? So hopefully, klaro po yung discussion natin. If you like more legal videos, may lalabas po yan dito na i-recommend ni YouTube algorithm sa inyo. And if you like to be notified kung may bago po tayong upload, subscribe lang po kayo. Until next time, see you all. Bye-bye!